Dictation starts. The plea of the appellants is that only that period can be excluded in computing the period of limitation during which assessment proceedings were stayed. A certain distinction was tried to be drawn in the instant case by referring to the interim order which was passed by High Court on 24th August, which has stayed the order of the department directing compulsory audit. It was thus argued that stay was limited only to conducting compulsory audit and there was no stay of the assessment proceeding. Learned senior counsel appearing for the appellants made a fervent plea to the effect that in the absence of any stay of the assessment proceedings, there was no embargo on the part of the assessing authority to proceed with the assessment even when the order directing special audit was stayed, and therefore benefit of the aforesaid explanation would not be available to the respondents. It was argued that the High Court had committed an error in giving the benefit of the exclusion of the said period on a wrong premise that special audit was an integral part of the assessment proceedings. It was also argued that explanation 1, as it existed at the relevant time, did not make any provision for excluding the period from the date when assessing officer directs the assessee to get his accounts audited till the date when assessee is required to furnish the report of such audit. Such an amendment, it was pointed out, is made in clause 2 of explanation to section 153B of the Finance Act 2013 to fill the lacunae that existed in the statutory framework, and this would also fortify the submission of the appellants that at the relevant time there was no such provision for exclusion of the time period during which there was a stay of special audit but no stay assessment proceedings. It was also argued that insofar as the provision relating to limitation is concerned, it needs strict interpretation, and certain judgments were referred to by the learned counsel in this behalf. Over. Thank you.